So this morning we continue with the Scandinavian legal realism. And from the recap we did earlier on, I noticed a good number of you after the lectures, you don't read even over the lecture or read around or think about we did. So that's not good enough. So you should make effort to be learning. So Scandinavian realism, as we hinted when we introduced legal realism in general, and then we veer off to discuss American legal realism last week. Scandinavian realism is associated with philosophers and law professors from the Scandinavian, that is Sweden, Denmark, and Norway, the Scandinavian countries. And unlike American realism, where the proponents or the scholars were so much fixated with what the courts actually do, for Scandinavian realism, the movement is characterized by a sustained attack on metaphysical nature of law based on their reading of Roman law. So for them, having studied Roman law, when you say Roman law, that is during the Roman Empire. I'm not talking about the Roman Catholic Church, I'm talking about the Roman Empire. During the Roman Empire, the laws which are there, the various codes, the Justinian codes, and so on and so forth. So having studied all those things, the Scandinavian scholars, the philosophers, they realize that a certain mistake, if I say mistake, that is something which is some kind of like a supernatural or something transcendental, as it were, is built around legal concepts, as if legal concepts by themselves exude or evoke certain magic, so to speak, certain mistake. And they thought that it was absolutely wrong for law to be perceived or viewed in that light. And that is why, for them, exposition of law has been unrealistic, as though law is different from the physical world. That is to say that for them, they say that the way people have been thinking about law and conceptualizing law, as if the physical world in which we have reality, our senses, touch, and everything, is very much different from the institution or the phenomenon we call law. So, like American realism, Scandinavian realism is concerned to explain law as it is, and not law as viewed in metaphysical sense, as viewed as if it exists beyond reality in abstraction. They rejected that. So, what are the essential features of Scandinavian realism, or the basic manifestations of Scandinavian realism? First, rejection of metaphysical speculation, and I will explain when we say metaphysical what it means, and then try to illustrate it so that it will make sense to you probably after this slide. So Scandinavian realism rejects metaphysical speculation, as I've said. They take the view that reality may be discovered or analyzed only through an investigation of the fundamental facts of the legal system. If we talk about something like bail, bail should not be taken as if there's something mystical, something magical, as it were, or something paranormal about it. It should be seen. When we say bail, like in reality, what is it? So that is the kind of thing that they are trying to draw our attention to. That we have to discover the reality of the law by examining basic or fundamental facts of the legal system. And for that matter, assertions which are incapable of proof, as far as Scandinavian realists are concerned, are complete nonsense. They don't make sense. Our morality is created by law and not law for morality. So it's not the other way around. It's not the case that the morality is there and for that matter, you try to create the law. No. For them, our morality is created by the law. And natural law is rejected by Scandinavian realists as being illusion, because natural law is largely metaphysical. For example, last semester we learned that natural lawyers hold the view that there are certain higher principles of morality out there to which man-made law or positive law should reflect or should approximate. Then you ask yourself, these are principles of law. Where can we locate them? Where can we observe them? And then Scandinavian realists will say that it's all an illusion. So don't take it serious. And for that matter, jurisprudential arguments derived from natural law, which is largely illusion, is also supposed to be rejected. It's unacceptable. So Scandinavian realists maintain that law can be understood in terms of set of brain's responses to groups of stimuli. So how do our brains respond to certain actions by officials in charge of the legal system and so on? So let's try to understand metaphysical, and then how this rejection of metaphysical plays out in Scandinavian realism. Now, in general philosophy, when we say metaphysics, is a branch that studies the nature of reality beyond physical, observer phenomena. So that aspect of philosophy investigation into knowledge, epistemic inquiry, which tries to go beyond what is physical, what our reality can identify or relate to, is metaphysics. So metaphysics will be dealing with questions like, what is the nature of existence? What does it mean to say that we exist? Do abstract entities exist? If we say abstract entities, for example, like we talk about the soul. We all believe we have soul, but can you use your senses to see the soul? No. What is the nature of causation? What is the nature of causation? What is the basis of moral values? Yes, certain moral claims are made, but what is the basis of them? So those kind of investigation to explore the nature of reality beyond physical observable phenomena, that is the focus of metaphysics as a branch of philosophy. So therefore, something is described as metaphysical when it refers to entities or forces that are not empirically observable, but are assumed to exist in order to explain something. So, like natural law claims, they are assumed to exist, so that we're able to explain certain things we need to explain, but we cannot actually prove them empirically. Use hard, evidence to prove them. So that is the point that we are trying to explain. So we mentioned examples of, metaphysical, like the soul, for example, or let's say the divine will, or moral truths existing independently of human beings, universal justice existing in nature. For example, remember your natural law, the Greek, the Roman scholar, the Roman scholar will tell us that the law will not be different in Athens, and it will not be different in what? In Rome. It's the same everywhere. So, is that true? Justice, universal justice, is this rare? Can we prove it? So all those things are treated as metaphysical. So for Scandinavian realists, we'll be dealing with them individually pretty soon. But for now, I'm just trying to understand metaphysical, which is rejected by Scandinavian realists. If you take some of their proponents like Azel Hagestrom, Avros, and Carl Oliver Kroner, the term metaphysical refers to legal concepts that are treated as if they were rare entities or forces, when in fact they are only linguistic or psychological constructs. So, certain things like, for example, possession, rights, interests. When you hear these things, the way they are used traditionally, you begin to assume that as if these things have any, binding force on their own, or certain binding significance on their own. And for that matter, Scandinavian realists argue that traditional legal theory often speak as though the following thing exists as rare powers, like legal right. If somebody says he has a legal right, what does it mean? Or legal duties, legal authority, legal obligation, or sovereignty. I'm say like sovereignty, what is sovereignty? And the way that in traditional legal theory or traditional legal usage, these words are used, deployed, they tend to suggest that as if they have something of bindingness on themselves, something like of a rare power, as it were. So, Scandinavian realists hold the view that these concepts, legal rights, duties, sovereignty, or legal obligation, are not rare objects in the world. We cannot imagine, we cannot see them, we cannot feel them. They are rather ways of speaking about social practices. So there are social practices embedded or social practices out there, and these labels are put on them. And for that matter, if we speak about these labels as if they are something in their own right, we are getting it wrong. We should rather be interested in the social practices to which they relate, so that they will make sense, they become rare, and they will no longer be just metaphysical. Therefore, when a traditional legal theory, for example, says that a person has a legal right to property, okay? A person has a legal right to property. Now, the realists, that is the not the American realists, the Scandinavian realists, will argue that this statement does not describe a mysterious legal force attached to the person. When we say that you have maybe like the a legal right to a parcel of land at Santase or parcel of land at Kuntanase, it doesn't mean that you have any mysterious legal force attached to you. Hence, that right, no, it doesn't work that way. Rather, it simply means that court will likely enforce certain claims in favor of that person. So if someone should go and start developing the land, which you said you have a legal right, and it goes to court, the court are likely to say that the person is not supposed to be there and it's rather yours. And for that matter, the statement that you had the legal right or you had like the title to that land on its own did not mean much. But what really matters is that when you decide to take up certain facts to the court regarding that land, and then the court will uphold your claim against the trespasser, as it were. Maybe let's, so in traditional legal theory, for example, we treat rights as though they are rare powers possessed by individuals. And we have example like A has a right against B. That is how a traditional legal theory or discourse will put it. And this sounds as if a legal power exists between A and B. But Scandinavian realists argue that this is metaphysical thinking because there's no observable entity called a right existing in reality. Can you use your senses, your eye, your hands, your nose, your ear, to actually observe something called a right? No. But the Windsor say that the statement A has a right against B actually means if B interferes, the court will likely order a remedy, just like the trespasser illustration that we talk about. And for that matter, the word right is simply a convenient legal shorthand. It's a legal shorthand, and it should not be taken as if it meant anything mysterious on its own, as it were. Now, question is, why Scandinavian realists reject metaphysics? Why do they reject metaphysics? Well, for Scandinavian realists, they were influenced largely by empirical and logical positivism, which hold that meaningful statement must be verifiable through observation or experience. So experience or sensory experience is very important in verifying claims rather than just taking things as if on their own they have any mystical force, as it were. And for that matter, Scandinavian realists argue that many of the traditional legal ideas are pseudo concepts. Pseudo concept, when you say pseudo concept, just like the like alias, just like a ghost writer. You use like somebody's name, maybe because the person's like famous or something in those days, especially where women were not treated well by society. You have a very fine female authors. They will write, and then you have to use a male's name or a famous person so that the book will be patronized in society. So that is like a pseudo authorship, as it were. So in the same vein, they said that many traditional legal ideas are pseudo concepts. They are just, if you like, labels. They are not rare. So Scandinavian realists sought to strip law of metaphysical language and describe it purely in empirical and behavioral terms. So let's use this illustration that they provide. So traditional concept, for example, say right. Now, for the Scandinavian realists, this right simply means prediction of court protection. That is to say that if I have a right to, uh, let's say, freedom of expression, or I have a right to something. Now, if you take certain actions in relation to me and I take it to court, the right that you are asserting is that a prediction. You're just trying to foretell that the court will give protection to the person who is asserting that right. In the same vein, when it comes like a duty, that there's a duty, that's the traditional legal usage. Scandinavian realists will say that what it really means is that there's a risk of sanction by legal institution. There's a risk of sanction, like so that if what the traditional legal theory will say that we have a duty. Now the Scandinavian realists will say that if you don't do a certain activity or if you do not refrain from a certain conduct, then legal institutions are likely to inflict certain sanctions on you. And that is the reality. So it's not just by talking about the duty as if the duty by itself, for example, is something binding or something magical or mistake. And again, authority, traditional legal concept we say like authority. The realist interpretation will be social acceptance of institutional power. So if you talk about the executive authority of Ghana, executive authority of Ghana is vested in the president. Now, that statement by itself does not really mean anything according to Scandinavian realist interpretation. What is important is that if the government or the president, for example, engage in certain activities, would they be tolerated by the citizenry as he having the power or being recognized as a person who can do that? If the answer is yes, then according to the realists, we are talking about the social acceptance of institutional power rather than just using a certain legal concept and think that that concept by its own evokes any bindingness, as it were. So let's use how this gentleman, Ross, he provided one illustration in his work to help us to understand this metaphysical rejection in Scandinavian legal realism. So Ross argued that statements of law are essentially predictions of judicial behavior. And for that matter, when we say, quote, the contract is legally binding, when we say the contract is legally binding, according to Avros, what we actually mean is courts will enforce the contract if litigation arises. So in law of contract, we have been told that pacta sunt servanda, sanctity of contracts, promises are sacred, agreement is binding. Now, in Scandinavian legal realist thinking, that or those statements, they are empty. They don't mean anything. More importantly, what we should be inquiring, will the court enforce the contract if litigation arises? So there is no invisible binding force inherent in the contract per se. And the idea of binding force is therefore metaphysical and is rejected by Scandinavian legal realists. So that's basically what they are trying to teach us. So maybe let's look at one more illustration before we continue. So just imagine someone saying, justice demands that this person owns the land. Justice demands that this person owns the land. For a Scandinavian realist, this is problematic, that saying justice demands that this person owns the land, because this cannot be empirically verified. You cannot verify it empirically. You cannot use the senses to ascertain whether what that statement is true or not, whether it exists or does not exist. And the Scandinavian realists treat it as the justice itself as metaphysical language. It's metaphysical language because it refers to a supposed moral force. So when you hear justice, I want justice. I want justice. The court must do justice. Freedom of justice. We hear these things and it conjures or evokes certain moral force as if they are entity in their own right. And this is problematic for the Scandinavian realists because it cannot be empirically verified. It cannot be proved empirically. Therefore, a Scandinavian realist will simply ask the question, what will the courts do? What will the courts do rather than just talking about justice in abstraction? So what institutional practice supports this claim? If you say justice demands that this person owns the land, that by itself appears to be metaphysical because immediately it does not lend itself to empirical verification or is not amenable to sensory experience, so to speak. So we should rather be interested in what exactly would the courts do, or what institutional practice supports the claim you are making that justice demands that this person owns the land. So basically, metaphysical legal concepts are legal ideas that are treated as rare forces or entities, even though they cannot be empirically observed. So when you say like metaphysical legal concept, that is essentially what it means. And we have emphasized this morning that Scandinavian realists reject such concepts and instead interpret legal statements as predictions about how courts and legal institutions will behave. So legal statements are predictions about how courts and legal institutions will behave. And that statement, predictions about how courts and legal institutions will behave, we are not hearing it for the first time. When we were discussing legal positivism last semester, we came across Hans Kelsen, and Hans Kelsen also used a similar language. So the other point we need to note about the features of Scandinavian realism is that legal ideas are mainly rationalization of social facts, as we'll be explaining, using the metaphysical in their construct. So you have social facts, and for them, if you talk about law is just expression of these social facts, and law does not exist independently from the social facts. So therefore, commands reflect illusions, which ensures obedience by their mandatory forms. So like, we have come across, command theory and so on. Commands by themselves are just illusions. But what is important is whether there's obedience to whatever is commanded. And again, they will say that values such as goodness are no more than the embodiment reactions expressing approval of a stimulus. When we say goodness or something is good by itself, it doesn't mean anything. But then maybe there's a certain scenario, a certain, facts, situation over there. And your reaction in approving or in endorsing that particular fact or scenario out there is what would let it be given the label goodness or otherwise, as the case may be. So let's take some of the proponents and discuss them a little bit more. As a Hagestrom is one of the key proponents of Scandinavian realism, and he's even said to have been like the founder, although it's debatable, but then the literature credits him with that. Hagestrom is committed to the realistic view of how law comes into being. So how does law come into being? And for him, metaphysics must be destroyed. So now we explain what metaphysics and metaphysical means. And Hagestrom believed that empirical analysis, which involves the acceptance of sense data as a source of valid information, will provide answers to questions concerning the origin, nature, and functions of law. So, to understand law, we must observe the legal system. You must observe the actual function of the legal system and its various components. So law is a necessary condition of organized social life within a state. And according to Hagestrom again, law is because it just has to be. You need law because we need to have an organized social life. And that is why law is supposed to be like the expression of the social practice, social institutions. And it's not the case that social practices or social institutions are supposed to reflect law. It's not the other way around. Again, Hagestrom reminds us that law is positive law made by human beings and located within the physical reality in terms of social facts. So, of course, we have already noted that all Scandinavian realists reject natural law school because of their concern that natural law school is all about metaphysics. It's talk about see the law as being metaphysical, meaning that the law is beyond our lived experience, so to speak, and that is rejected. And they simply embrace the notion that law is essentially man-made, is positive law. And for that matter, it is located within our physical reality in terms of social facts, what goes on in society. And natural law is rejected as false, if not meaningless, since they locate the law within God or state, or like even some the reason. So the metaphysical or the spiritual reality of ideals and values that cannot be conceived alongside the physical reality. If we look at the various natural laws that we look at, you notice that how they locate law and then the principles of morality is really difficult to use our empirical experiences to relate to them. And for that matter, for Hajjastrom, it is impossible to identify any unitary will behind positive laws. And this implies that the will of the sovereign is a metaphysical idea that must be discarded as meaningless. Because for him, law cannot be conceptualized as a system of authoritative norms concerning the rights and duties of a person. So there's nothing like, you have like just a one sovereign, so to speak, as the command theory will tell us, that expresses their will through the issue of commands backed by law. Hajjastrom says that that is to be rejected as meaningless because it's not really possible to view or conceptualize law as a system of authoritative norms. So he asks that rights, duties, obligations are meaningless concepts as they are not rooted in actual experience. They lack any empirical significance until particular state of affairs are challenged. So the term right, for example, has a meaning only when associated clearly with remedies and legal enforcement procedures. And here we begin to see some relevance of Hoffeld's analysis of rights, particularly when you talk about the claim right having the corresponding duty bearer. Otherwise, if you just say that you have a right and we cannot relate it to reality, what is the point of the right that you are talking about? And Hajjastrom is also making a similar point that if you talk about right, you talk about duties, obligations, they don't mean anything unless we can situate them in actual experience, in actual factual scenario. So if the right you are claiming to have, if it is breached or violated, can you get remedy? Are there enforcement procedures you can trigger? If the answer is yes, then you have a right in the true sense of it. Otherwise, it will just be metaphysical. And Hajjastrom believed that the term justice represents in reality no more than a personal, highly subjective evaluation of some state of affairs, of which we generally approve. So if you say justice, maybe from your subjective viewpoint, whatever you are looking at is fair, and for that matter, you endorse it. So people are persuaded to obey law as a result of conditioning, and society accepts, because of long historical periods of training, that certain rights exist as a result of series of particular types of what event. So we have been conditioned to actually accept the law. For example, when all of us were born, we came to meet so many laws and so many do's and don'ts. And through socialization and so on, we become conditioned to accept them as they are. And then we try to obey them as it were. Another contributor to Scandinavian legal realism is Carl Oliver Kroner. Carl Oliver Kroner is from Sweden, and he made the argument that law exists in a factual sense only. And to him, the significance of words printed on paper or internalized in people's minds is that they form a link in the chain of causation which results in the causes of behavior. So what we call law, what is written on the statute books or in the case law, as it were, is just is connected to how our mind, for example, see how phenomena is caused. And for that matter, our behavior is adjusted or patterned accordingly. Now, for Olive Kroner, law is little more than a form of psychology. It's rather a symbolic expression for the fact that the human mind responds in certain ways to various forms of social pressure. So, I mean, human mind, your environment, you hear a sudden movement in your environment. Let's say that I'm in a room. I hear something like dropping or falling down. Instinctively, I will tend to look at it. So that's like the stimuli. I respond to it. And the same thinking in Carl Olive Kroner's view applies to law. So lawyers and officials read the laws enacted by the legislature. And by virtue of their conditioning, they are induced to act in particular ways. So the judge decides X, the policeman enforces X. You go to like the court, for example, the judge will just make an order that, yes, this person is found guilty of this offense and convicted accordingly. This person is sentenced to 2 years or 25 years. Then immediately, the CWO, the court warrant officer, the police man over there, will have to take over the person. And the person will be processed and then taken to the appropriate prison and handed over to the prison officials. So here, you notice that the policeman, the prisons, and everybody are conditioned to accept that when this pronouncement is made by the judge, then these actions will follow, as it were. So to Olive Kroner, a monopoly of force is required for the psychological basis of the law to be effective. And he suggests that the law is in fact the progenitor of many of our moral standards. So here, it's reinforcing the view they've already told us that morality is expression of the law and not law reflecting morality. That's essential that they're trying to tell us that in many ways, law gives birth to various moral standards. So we are at an early age conditioned into accepting that certain conduct is unlawful. So, for example, we have the law on stealing, isn't it? And as you are growing up, you are told that if somebody's property is lying there, don't take it. Otherwise, it's stealing. Now, you may not be told the details of all the provisions of the criminal offenses as relating to stealing, but then you are just told that it's stealing. And over time, it is worked into your subconscious, and you try to live your life in a way which will let you avoid engaging in acts or conduct which they will characterize as what? As stealing. So you are conditioned into accepting that it is unlawful. So the stamp of illegality lends these rules a particular power. It gives a certain power to it. So we quickly learn to internalize these rules, and they then come to be our standards of morality. So something like, let's take this LGBT, for example, or natural canal knowledge. We have the provision of our criminal offenses relating to unnatural canal knowledge and so on. And so from day one, we accept that it is not right to indulge in that. We have the homicide, the offense of murder. So you are conditioned to know that it's not lawful to kill another person. So all these matters which are already found in the law will become our way of life. And over time, we are not just living because the law says, because we think that that is right. And that is why he's trying to say that law, as a matter of fact, is the progenitor of many of our moral standards, if not all of them. If not all of them. You take something like traffic light, okay? Traffic light, almost every citizen, when you get to the traffic light, whether the police is there or not, when it is red, you will stop. Because over a long period of time, we have been conditioned to know that it is against the law to drive when it is red. And it becomes part of us. We internalize it. It becomes part of our subconsciousness, so that we even do it as if we are morally obliged to do. So Olive Kroner believed also that the origin of law was simply a matter of fact, and is not a matter of what? Abstraction. So law is originally coercive, meaning that if you don't do what it expects you to do, force will be visited upon you. Sanctions are provided for infractions of the rules. Individuals are then faced with the choice between compliance and disobedience. So in this time, this process becomes too onerous for most of us, so that both the temptation of committing the act in question on the one hand, and the fear of the possible sanctions on the other, are sublimated or repressed into our subconscious mind. In our subconscious mind, we simply retain an imperative symbol such as "you shall not." And the rule has therefore been internalized, and there is now normally no need for threat of coercion. So initially, the threat of force or punishment is what will let us obey the law. But over time, the threat of punishment may fade into irrelevance when our subconscious has accepted it as the right thing to do. And then we'll do it without even thinking of the fact that if you don't do it, we are going to be punished. So that is what Olive Kroner is telling us. And to a large extent, we may see some truth or some veracity in this observation. There are a lot of things we do in society which we don't necessarily think about the punishment, although initially the punishment was a motivation for us to obey. But over time, it becomes internalized in us so that we are not so much fixated with the punishment or the threat of it. So according to Olive Kroner, the rules of law are independent imperatives and not commands are generally understood. So, legal positivists will have told us that, the law is a command. But Kroner is saying that no, they're independent or standalone imperatives. So according to him, it is false to think of law as the commands of an actual person. For no human being will go about commanding all that is contained in the law. So there's no personal relationship from the issue of the command and the party to whom it applies. So he says that it's just not realistic. It's just not practical that any human being can actually command all that is contained in the law. If you're actually looking at law as a set of commands, then say that is not possible, because command presupposes that there's a certain personal relationship between the issuer of the command and the party to whom it applies. But is it really the case that if you take the assemblage, let's say assemblage of all the laws in the Ghana legal system, can we reduce it to the sort of personal relation between the issue of if you look at them as a command, and the citizen to whom they are directed? So that is what he is telling us. So the rules of law within the legal system are now largely independent imperatives that have passed through a series of recognized formal activities. Citizens give obedience to such imperative because they be conditioned to behave in such a manner. Let's take Ghana. When it comes to laws, we know that our constitution has set up a parliament. Article 106 provides a procedure for making laws. The parliament, the president assent, is gazetted, is a law. So we have been conditioned. So we may have MPs' friends that will sit at the drinking bar or at the restaurant or any recreational place, and to have normal conversation with the person, maybe talking about something, and then the person will be talking about the fact that he wants, he thinks certain things should not be permitted. Now, when he tells us at that place, it's just his, private or personal, wish, and we don't take it serious. But then when the same thing has gone through the lawmaking process, is reduced into writing as a bill, accompanied by explanatory memorandum, it goes through all the first reading, second reading, third reading, consideration stage, it is passed, and then the president assent to it, is published in the Gazette. We will obey it without any questioning. The same thing which our friend MP has talked about when we're sitting at the recreational center or the restaurant or the drinking bar. At that time, it wasn't taken serious. But then when it has gone through the process, which in the legal system we recognize as a formal way of doing it, we will immediately obey it. So that is the kind of thing Corona is reminding us, that the rules of law within legal system are largely independent imperatives that are passed through series of recognized formal activities. And citizens give obedience to such imperatives because they have been conditioned to behave in such a manner. Or let's take the example of our current government, the 24-hour economy. During the campaign, when the president and his party were talking about 24-hour economy, it was seen as something which cannot happen. So it wasn't taken serious by, let's say, Ghanaians. Now they go through the lawmaking process, all the formal ways of recognized as making a law. And now it is a law. And all of a sudden, everyone will relate to it without even remembering, the doubts and how funny it had probably sounded when it had not become a law. But now that is going through law, because of how we are conditioned, we all accept it and obey it. That is the kind of thing Oliver Corona is trying to teach us. So, custom, tradition, feelings of social solidarity and duty, and the residue of generations of historical development combine to assure the binding, non-optional character of independent imperatives. So many factors. The fact that we have our custom, our cultures, and so on, and then the fact that we lean on one another in society, support one another, and we have what they call the intergenerational equity, in the fact that one generation should be mindful of the fact that that generation is not the only large generation to live, and there will be generation after. And everything that you are doing, you have to be mindful of the next. Just as in our own lives, as individuals, we don't see ourselves as being the last human beings to live. Now, after we are dead and gone, others are coming after us. And all those things should influence how we actually live in society and organize things. So that is the kind of thing Oliver Corona is trying to tell us. So the reality to which law must consist or correspond of the psychological reaction of individuals. So these psychological reactions are the ideas of imaginary actions and the sensations of compulsions and restraint produced when a provision is brought to our auditory or visual attention. In other words, he's trying to look at the fact that when a law or a rule of law, for example, is drawn to attention, the kind of emotions, the kind of reaction which take place in us, that is what he is using to explain the psychological dimension of the law. So Oliver Corona classified law into voluntarism and non-voluntarism. And what does it mean by voluntarism and non-voluntarism? Now, a proper theory in Oliver Corona's view must be a non-voluntarist or a realistic theory of law, where legal rules are conceptualized as independent imperatives to be distinguished from commands. So legal rules are not just commands, because already he has told us that it's not possible for one person to be the issuer of all the commands contained in the law. because of impossibility of establishing personal relationship between the issue of the command and the person or the people to whom the law is actually directed. Now, natural law theories and positive theories belong to voluntarism, since both theories claim that law is the expression of the will of the supreme authority, and they only differ with respect to locating the supreme authority in God or state. So natural law believe that law is the expression of higher principles in morality, that is the Almighty God, or the reason or the nature. Now, legal positivists also says that law is the expression of the will of the sovereign. If you look at Austin and Jeremy Bentham, that law is the command backed by what? By sanctions. So in that respect, both natural law and legal positivists, they all see the law as reflecting the will of someone. But then what they differ is where the will of that supreme authority is located. One will locate it in in God or state of nature, and another will locate it in the human ruler or the sovereign, as it were. We have another scholar, and we'll be finishing with Scandinavian realism soon, Avros. Avros was a Danish jurist who believed that jurisprudence is an empirical social science, and law takes the form of a system of normative rules. So, to our force, law is a system of normative rules, and its validity rests on the possibility of one being able to predict that the rules are likely to be applied appropriately in future disputes. And then it doesn't rest on transcendental notions, that is metaphysical notions. So he looks at law as you being able to predict how things will look like in future based upon the law. So for Ross, legal rules govern the entire set of institutions and agencies through which actions ascribed to the state in its legal capacity are undertaken. You have like the various institutions of states, the various arms of government, the agencies, parastatals, and so on. And all this, they function through law. So the primary rules, which are followed with regularity, and which may exist as psychological facts only, and for that matter, inform citizens as to how they are expected to behave, become binding. And we've met primary rules in Hart's concept of law, but also being used in a different sense by Avros, a Scandinavian legal realist, that the rules which we follow without questioning, that is, with the regularity. And we have noted that they may be psychological facts, in the sense that they inform citizens how they are expected to behave. And for that matter, the primary rules become binding. Not the rules themselves, but because of how they operate in us. Then we also have secondary rules, according to Avros. And the secondary rules specify sanctions and conditions under which they will operate. So predictability of the operation of the rules, that is the experience of validity, induces confidence in them. So to know the secondary rules is to know everything about the existence and content of law. So maybe if we are to relate it to our legal system, we can use maybe either the dispute settlement, the court structure, jurisdiction in relation to various types of disputes, or we can even use the sources of law, Article 11. And we also have Lancet, who is also a Swedish jurist. He was a lawmaker, and he also made some contribution to Scandinavian Legal Realism, and he believed that metaphysical interpretations of the law ought to be rejected, and we've been seeing this consistently across Scandinavian realism, and that which can never be proved is no basis for investigation of what legal phenomena. So the province of legal science, the province of legal theory, according to Lancet, should be about something which lends itself to investigation. So if you cannot investigate practically, then it shouldn't be part of law. So Lancet argued that judicial concepts of rights, justice, are elusive, as there is no scientific method of evaluating their basis, and they are merely labels pertaining to consequences of certain legal procedures. So if we talk about like justice in Ghana, can we measure it? Can we use the same measurement for it in, let's say, Nigeria and so on? Certainly not. So law, according to Lancet, should be interpreted simply as a fact of social coexistence, and the legal order is essential to the continued existence of society. So very simple and practical view about law, and nothing more. Just like the American legal realism, and for that matter, all legal theory, no legal theory or no intellectual construct has immunity from flaws. So in the same vein, Scandinavian realism has also got a downside. And if we look at the literature, we notice that the movement has abandoned a former metaphysical interpretation of the law. It seems to have substituted its own new metaphysics. So just like the metaphysical claims of the law, which they have rejected, it's like they have introduced another version of metaphysics. And that's why we say that they seem to have substituted with their own new metaphysics. So a search for essential characteristics and features of the law appears to presuppose a transcendental phenomenon in the same category as the ultimate essence of law, associated with some natural law doctrine. So in a sense, you have castigated traditional legal theories, and you have made the point that all aspects of the law and legal thinking that cannot be reduced into empirical investigation should be rejected. However, you've also set yourself the task of trying to determine and construct the essential characteristics or features of the law. And that in itself is going to result in the very thing that you have condemned as being inappropriate. So the view that law creates morality, which is one of the claims of Scandinavian legal realism, seems to be contrary to historical evidence. If you look at history, we have examples to refute the claim by Scandinavian realism that morality is created by law. Let me give you an example. Let's take the Universal Declaration of Human Rights, which was adopted in 1948. Now, if you examine the statements therein, you notice that the fundamental rights and freedoms which have been enshrined in that declaration, if you look at the preamble to it, it's not the case that the instrument is creating it. It's recognized as something which is inherent in us as human beings, and for that matter, the morality existed, as it were. And again, if you look at the widespread abhorrence of murder, murder is not our law, it's not our Criminal Offences Act, other than the 1960 or the colonial era one, which created that. Murder has always been wrong. So it is not the law which is creating that morality. So due to the abhorrence of murder and the moral imperative which reflects murder, it has resulted in the strict legal rules relating to consequence of unlawful homicide or murder and also manslaughter, as the case may be, and not the other way round. And there are many, many, many examples in which we can use to support the view that law does not create morality. Morality actually exists, and law tries to reflect morality. And that is a critique to one of the claims of Scandinavian realism. Again, we have example from history of the law where lawmakers or legislatures bow to pressure of strong morally inspired feelings of citizens. Let's take the US. If you take Martin Luther King, the civil rights activism, the segregation between the blacks and the whites in the US, in the apartheid South Africa. Over time, laws were made to actually abolish that. And those laws came because of certain pressure, which advocates or social activists were actually mounting. And those activists were not speaking from law, they were speaking from moral convictions. And subsequently, if law is made to abolish those things, then it is not the law creating the morality. The law is rather reflecting the morality. Yes, I think we will end the discussion here and take any questions we may have, because we have to switch to another model, company law, and the other students are waiting. Okay, I don't see any hand up, so I presume there's no question.